Hi, I'm Brian Heidelberger, a partner with the law firm of Winston and Strawn in Chicago. Here today with your Advertising Age mini law lesson. Today's law lesson, can brands use celebrities in social media without permission? A good question that we're going to get to the bottom of. But first, business development says I don't smile enough in these videos. And while I'm generally not a fan of smiling, I thought that this slide might help matters. So what are we talking about? Well, anything you do on social media is very likely to be seen by a celebrity as marketing if you're doing it on behalf of a brand. And if you use name or likeness for a commercial purpose without permission, we may be considered in violation of the law. And yes, it's true, I like to make a few YouTube videos of me lip-syncing Lady Gaga on my own time, or maybe even tweet about that Boyz II Men reunion that I want to see happen. But that's my personal time, and really isn't that what the Founding Fathers fought for? But on the other hand, when you're creating advertising for a major brand, you're subject to a whole different legal standard under the First Amendment, and we don't have those same kinds of protections. Now, can we go to a celebrity for permission? We certainly can, but minor uses aren't necessarily going to be seen as minor by a celebrity and could cost big bucks. You got to know that going to a celebrity takes a lot of time, and just telling them that it's free advertising for them is generally not going to be persuasive. So let's get into the risks here. Now, let's remember, I'm not talking about violating a celebrity's rights. We're looking to see, is there a way to do this and still stay within the confines of the law? But we need to understand that any way you cut it, you could get sued. Celebrities are litigious, court decisions are inconsistent, and even if you quote-unquote pull it, it doesn't mean they're going to go away. Juries have held $14 million in damages in the past, so you want to be really careful when thinking that there's nothing bad that can happen to you. And even if you fend off that celebrity, you're going to spend a lot of time and money and legal fees, frankly, on doing it. And so the question really should be here, not is it legal per se, but what is the risk of getting a serious complaint? And if it's high, you better know that going in before you take this on. So let's look at the risk spectrum. And when I'm talking about risk spectrum, again, I can't tell you whether a court is going to hold one way or another because the court decisions are inconsistent. So what I'm really talking about is the risk of getting a serious complaint that you can't fend off. Let's say a celebrity tweets you because they really like your brand. Can you tweet back to them? Well, I think that one is pretty unlikely to receive a complaint. Similarly, if a celebrity positively mentions you in social media and you mention them back by saying thank you in a way that doesn't suggest endorsement or affiliation, again, I'd be pretty surprised if you'd get a complaint there. What if you like a celebrity's page? I think that's, or follow one, again, I think that's not something that's likely to get you into trouble. What's also on the cold scale? Well, a celebrity tweets and you retweet it. If you don't suggest endorsement or affiliation and are merely retweeting it, one could argue that the celebrity has kind of accepted that fact that that might happen merely by being in social media. What if you want to link to a celebrity's an article about a celebrity? Well, if you don't use their name and you merely link to that article and which takes you off to another page, again, I would be pretty surprised, especially if that's a positive article. I'd be pretty surprised if you got a complaint. Now we move a little higher in the risk spectrum. I hope you like my color coding. We're at the yellow stage. If you tweet or post about a celebrity who happens to be in the news, and you're talking about it in the newsy type context, that's in the warm category. And while you may have some legal arguments there that what you're doing is legal, it's risky. You very well might get a serious complaint. What if you just congratulate them on an accomplishment? Well, that one, I guess, again, is in the warm category because the court decisions are a bit inconsistent. You see, recently, Michael Jordan sued a grocery retailer who used his name and his shoes in an ad congratulating him on being in the Hall of Fame. He actually sued for $5 million. Now, the lower court held this to be a permissible First Amendment protected use, but he's appealing that case, and we'll have to see where that one goes before we could put it in the cold category. Now, what's in this hot red category? Well, if you are posting the picture of a celebrity that you have no connection with, you're posting their name or tweeting their name when you have no connection, I'd say you're in a hot category there. If you tweet to a celebrity time and time again with no connection to them, again, you might be taking advantage of their brand in the social media space. What about doing a Facebook poll about a celebrity? Well, there you want to look a little bit as to who you are, but if you're merely a brand, it's going to be a tough one and the kind of thing that, again, you could get a serious complaint about. And we talked about Pinterest pinning a picture of a celebrity to your pin board, even if they wore your product or used your product in public without their permission. That one seems to be pretty risky. Because if the celebrity didn't expressly engage you, using them to promote your brand is the kind of thing that they're going to see as something that they need to get paid for and might conflict with exclusivity provisions that they have with other sponsors. Now, don't take celebrities' posts in social media and bring them into your advertising outside of social media. For that, you certainly need permission. Let's look at a couple lawsuits. Burberry was sued by Humphrey Bogart Estate when they posted to their Facebook page a picture of him wearing their trademark raincoat and used his name on the website. Similarly, Sandra Bullock sued the toy watch company when they posted a video with a statement saying, "See the watch here that was worn by Sandra Bullock in the movie The Blind Side." And while it was a true fact, Sandra Bullock believes that this is tying her personally to this product endorsement. Similarly, Thermador was sued by the Julia Child Foundation, and while it's a true fact that Julia Child did use the Thermador oven for many years, when they posted a picture of her and the oven on their Pinterest page and statements about her on their Facebook page, the foundation believed that it was too close of a tie for commercial purpose and sued Thermador. Now, there is a recent case that does provide us some light, but we do want to be a little bit careful about it because we don't exactly know if other courts are going to follow it. In this case, Samsung created an app which took users' Facebook profiles and then made connections to Olympic athletes. Now, the Olympic athletes used in this app sued, claiming a right of publicity violation, and the court actually held that the app was protected speech even though Samsung derived some brand benefit from that. Now, that's a great case for those of you who want to use celebrities in advertising, but we want to see how the courts go from here, and do courts follow that in the future. Now, if we decide to elect to take the risk, we want to mitigate it as much as possible. So let's not use celebrities who have sued often or are considered litigious. Let's not use celebrities who have a strong reason to bring a claim against you, such as that they're an endorser of your competitor, they have a big project coming out, you're using them in a negative light, or your product is something that they just really don't want to be associated with. And you certainly want to avoid high-profile uses which are very costly to change. That's the kind of thing that can get you into hot water. Now, if you do get a letter from a celebrity, what do? Well, don't freak out. Look at my past video on adage.com, how to handle a cease and desist, or you can go to my YouTube channel, youtube.com/Brian Heidelberger. And that's it for today. Let's be careful out there. Hi, I'm Brian Heidelberger, a partner with the law